Okay, this is the first video for the final unit. 2+ years ago, when the College Board AP program restructured the government curriculum, they moved civil rights and civil liberties, which was a separate, fairly short unit, from the end. It had been, I think, unit 5 or 6. In fact, I think there were 6 units at the time. It had been at the tail end. And it sort of made sense coming right after, as we're doing it, as I still do it, right after the judiciary unit. In restructuring it, they, for whatever reason, decided that since it was based so much on the Constitution and a little bit with constitutional federalism and how that developed, that they moved it to after the first unit. So even it's still misnumbered here on this slide, it's now Unit 2. Because it is unit 3, excuse me. Because it is unit 3, it's going to be one of the 3 units that they could potentially draw on for these 2 questions that they're creating. So it's kind of long. It involves a lot of court cases. The ones that are must know, that is they will not accept any complaining about how could you bring this case up, is the 15 that were in the previous video. Now, that being said, they're excluding the SCOTUS, the Supreme Court question, which is now in their new formulation question number 3. They're only doing question 1 and the long form essay question 4. That doesn't mean they couldn't still incorporate Supreme Court cases somehow, some way in this, since they only have 3 units to pull from. However, then the counter argument to that is they're only making 2 questions, so we shall see. I mean, this is the great unknown. So I'll begin to walk you through this process. Of this will probably be over 2 or 3 videos, the whole notion of civil liberties, and then the last one on civil rights will be probably a single video. Now, the first issue involves this distinction between what are referred to as negative rights and positive rights, and I think it's a worthy enough subject to talk through, to know about, given the fact that they're not going to have a SCOTUS question, and they're only going to have 2 questions for this particular exam. I don't know how relevant it is. The founders would have been very familiar with the notion of negative rights. I mean, this was the rallying cry of George Mason and his troops, was we need to have spelled out restrictions on aspects of life that the government can have nothing to do. Madison countered that by, I mean, you can get a government to write down anything you want, but unless the government is structured in a way to protect those rights, it could violate it. It's just, he referred to it as a parchment barrier, a piece of paper, that any government, I mean, the Soviet government of the 20th century had an elaborate constitution and an elaborate quote-unquote Bill of Rights. Doesn't mean it wasn't oppressive. It was very oppressive. So that was sort of the art. So the original founding view was that any sort of statement of rights was going to be about things the government could not do. Think negative not, could not do. It is mostly associated with the First Amendment. It cannot interfere with your right to choose a religion, practice that religion, and it can't impose a religion either actively or passively. It can't interfere with your right to express yourself through speech, through the printed press, etc. Now, and keep in mind, and we'll come back to that shortly, that none of these are absolute. You don't have an absolute right to practice whatever religion you want. You do more or less have an absolute right to believe whatever you want. It's actions that tend to get you in trouble sometimes in that realm. So, and several states had these things, these lists of, Congress. Well, think of the opening line of the First Amendment: Congress shall make no law. So those are negative rights. Positive rights are just the flip side. These are expectations you have from your government. How are they supposed to be? What are the expectations on them? What must they do for you? To some degree, we even see the blurring of that. We're still talking about the Bill of Rights. When you look at the 4th, the 5th, the 6th, the 7th, the 8th amendments that generally have to do with various aspects of the judicial process, they're a description of how, when the government does arrest you, and it is allowed to arrest you and put you on trial and punish you. What are the expectations on it, and what's the process to do that? To some degree, and we'll talk about it down the road, probably in the next video. It's very methodical. Each step of the process has certain expectations. You could view that as sort of negative rights. You know, you're not when they, they cannot put you into an unfair trial circumstance, which they were very familiar with from what they felt like was the king's violation of this status, as they were just colonials and he was free to do with whatever he wanted with the judicial system. We get to the 20th century. Uh, Governments are now stepping up and writing in their constitutions expectations of things they will do for the people. Probably the most obvious one is early on, states started providing educational services. It is even written into the last Virginia state constitution that was drafted in 1971 that all you fine young people have a constitutional right to be provided a full, fair, and free education, something to that degree. So we begin to transition to this notion of expecting certain things from the government. And then the final piece of the puzzle is, how is the government going to deliver those services, the expectations, particularly for equality, something that we'll talk particularly in the civil rights video, which will be down the road. I think that transition is a perfect example, and I would have liked to have had this in class, put it up on the board, is that poster from Roosevelt's speech on the four freedoms. The first two are classic negative rights, that you should be able to worship as you wish without government interference. You should be able to speak, express as you wish without government interference. Then it gets to freedom from want and freedom from fear. The government's supposed to step in and provide you things so you want not. You have food, you have shelter, you have employment, and freedom from fear. I think the government is going to provide all of these services to protect you and keep you safe. To some degree, that has relevance to healthcare. In terms of want, I think the perfect law to look at for that would be the Employment Act, I believe, of 1947 or 48, where it sort of made it the government's responsibility to see that people had jobs if they wanted one. That would have blown the founders' mind. The Affordable Care Act might be you don't need to be fearful of your being able to maintain your health and obtain health services. The government will step in and provide that for you. And then in the 21st century, and we're struggling with this right now as we the entire country try to transition to online education. Do you have a right to high-speed internet access? I think I put that on the slide originally, because there was actually a story, some advocate for this, and they even used the expression, you have a right to this. It's present in America, and because it's present in America, the government must then provide it to everybody in every town, village, farm, field in this country. So it's a big leap, but it's where we are in the 21st century. We expect so much from our government beyond just not doing things to us, sort of the negative founding original view. Now, why this has become, and it goes back to more than a century, but why is this a matter of such importance for a U.S. government class? It wouldn't have been. It would have been much more clear if the decision in Barron versus Baltimore in 1833 would still be the decision today. In that case, the city of Baltimore had taken something of value from Mr. Barron by doing something, and he felt like he needed compensation. And there is a portion of the Fifth Amendment called, I think it's the Fifth Amendment, called the Takings Clause, that you have a right to be compensated when governments take property from you for public use, something referred to in legal terms as eminent domain. It went to the Supreme Court, and John Marshall, said, "I really feel bad for you, Barron. Baltimore probably should compensate you, but this is the Fifth Amendment to the U.S. Constitution, It only would apply if the U.S. government had taken your property, taken value. If you want to pursue a state, you've got to hope that there's something in their constitution, their legal system that will do it for you. Essentially, what he was saying was the Bill of Rights, in particular, 1 through 8, only applied to actions of the U.S. government. An example I always throw out there, as late as the 1830s, communities in Massachusetts were using tax money to pay their congregational ministers. Something I would like to just be completely out of the realm of possibilities in today's world. But the First Amendment, the Establishment Clause regarding religion, did not apply to the states. They were free to make whatever choices they wanted to regarding that. After the Civil War, you'll note the key moment in all of this is the creation of the 14th Amendment. It was in particular response to the slowly restored governments of the former Confederacy reusing state power to, while not reinstituting slavery, essentially restoring sort of a slave-like culture and code. Remember the Black Codes. So the radical Republicans in Congress decided, well, we know, there is one avenue that will, no pun intended, trump actions of states, and that is a constitutional amendment. So before the southern states were fully integrated and would have changed the calculation and getting to 3/4 of the states ratifying it, they wrote the 14th Amendment. For our purposes, it's the first section that matters, although the 5th empowers Congress to enforce what the first section says. Sections 2, 3, and 4 had to do with the status of the former Confederate states, their debt, and their former leadership. The first thing you'll note is it defines citizenship for the first time. It defined birthright citizenship, that being born in the United States makes you a citizen. And then once you're naturalized, that is a law created by Congress. Congress, under the Constitution, has the duty to establish naturalization laws. However, once you are naturalized, you are treated the same as a native-born citizen, with the only exception being becoming president, the only one. And then it laid out, okay, what do you get for this? What's behind door number 1? What are your prizes? Well, you get 3 things according to them. You get the privileges and immunities of all citizens in all states, no matter where you are. You are to be treated equally, whether you were born in New Hampshire and moved to New York, or moved to California, or are traveling between states, that there should be no mistreatment of people or different treatment of people, or maltreatment perhaps of people as they move from state to state. The authors of the 14th Amendment, in particular a congressman from Ohio named John Bingham, intended that clause, that privileges and immunities clause, to apply all the rights in amendments 1 through 8 to everybody in every state, to every government. So the Prince William County could not establish a religion. The Commonwealth of Virginia could not deny you free expression. You had a right to a jury trial in Iowa, and so on and so forth. Amendments 1 through 8. Essentially to overturn Barron versus Baltimore. Remember, a constitutional amendment even trumps a Supreme Court decision to say that that's not the case anymore. We are literally changing our constitutional structure to say, and maybe finally achieve, maybe George Mason is smiling from heaven, finally achieve their desire to have this clear statement of rights protecting you from every government as a citizen, naturalized or born in this country. They also required that states provide due process to everybody. Now, at the time, it was something referred to as very important procedural due process, that steps be known, steps be followed, and steps be consistent from one person to the next, from one state to the next. Later on in the 20th century, there emerges something called substantive due process, which is very important for the Brown decision that we'll talk about later. And then finally, the equal protection. All people should benefit from the equal protection of the laws. And that obviously has relevance later in the 20th century and even to the 21st century. Now, that box to the side with the circle around it, the Supreme Court, a decade or two later, starts getting challenges to this interpretation. By this time, the radical Republicans are no longer in absolute control of the Congress. I think in the middle of this, the first Democratic president since James Buchanan is elected, so they don't run the show as much. The Supreme Court tends to be very backwards looking, very traditionalist. So they issue a series of rulings late in the 19th century that, in this circumstance we don't have time to go into, that essentially interprets the 14th Amendment differently, that the Privileges and Immunities Clause, because the writers left it kind of vague, even though the record was pretty clear, does not automatically guarantee you from the state protections of the U.S. Bill of Rights. Equal protection, this had to do with the slaughterhouse cases that you might have learned, only applied to direct state action. So this opened the door to private enterprises treating people differently based on their gender, based on their race, based on their religion. And I think the ultimate expression of that is the decision of Plessy v. Ferguson, in which the court lays out this obviously phony assumption that somehow if facilities are equal, which they weren't 99 times out of 100, if not 100 times out of 100, then it was okay to identify people by race and by extension by gender or ethnic origin or religion, and treat them differently, private enterprises, and even by extension, government enterprises as well, as long as they were being treated equally. So we enter the 20th century with essentially us existing in a Barron versus Baltimore circumstance. That the high-sounding words of the First Amendment, the Fourth Amendment, the Seventh Amendment, etc., did not necessarily apply to the actions of state governments, state and local governments, that they were tied to just actions of the federal government, which until the Great Depression is still a pretty small government, not really doing that much. So what changes? Well, gradually the court changes its mind, but gradual is the key word here, and part of that is it's just now different Supreme Court justices. It is now a new century. Post World War I, America has changed dramatically. There was a shifting in population. There was a massive growth of industry, a growth in urban areas in particular. So the court begins to at least consider the notion that the Bill of Rights should protect you from any government. And they could have taken a case, much like they did when they ruled the other way, and say, we were wrong in the slaughterhouse cases, in the civil rights cases. We were wrong, and we're just changing our minds. They're reluctant to do that. We talked about that in the Supreme Court video, or I talked about it and you listened. So they're reluctant to do that because they worry what it's going to do to their reputation, to the degree of deference that is paid to their decision. So they chose a different path. They chose what you're seeing in this slide, something referred to as gradual or selective incorporation. If you, and you can see it on the second slide, and I don't even know how the numbers work out there, but if you break out each particular right or expectation or freedom that you have in the first 8 amendments, it comes to 24, 25, 26, somewhere in that range, depending on how you decide to categorize them. So what they decided to do was take them essentially one at a time, get a case that had to do with that particular freedom, that particular right, and say it now applies to all governments. And they led off this in the 1925 case of Gitlow. It had to do with protesting the, I believe, draft during the First World War. And they, in their decision, ruled that yes, you notice it's Gitlow versus New York. It's always going to be a state involved. That New York was wrong in this particular case to not consider the First Amendment protection of free speech. And oh, by the way, from now on, you can challenge violations of your free speech by state and local government in federal court and expect it to be protected by the First Amendment. So they pick speech expression as the first one to add or incorporate into protections against any government. Now the irony here is they just did it as a precedent for the future. They didn't actually rule in Getlow's favor. Getlow still had to serve time for advocating against the government's action. Now, I wish we had a lot more time with this. They initially focused for the first 2 decades, pre-Depression World War II, post-Depression World War II, 2.5-ish decades, on just the First Amendment, which are sometimes referred to as fundamental freedoms. George Washington's nephew was a justice on the Supreme Court in the early 19th century, Bushrod Washington. He actually, in a decision called Corfield versus Coryell, I believe, expressed the notion that maybe the First Amendment should be treated differently. And the court 100 or so years later decides, maybe he's right, that we're going to focus on these fundamental freedoms first. And you'll notice on the second slide where you see the sequence, it is indeed the First Amendment that goes first, speech leading on. But they focus initially on those, I hate to label them as the most important, but those fundamental rights to exist in a society that would apply to everybody, or pretty much everybody. It's only in the 50s and 60s, you'll notice again on the list, where they begin to focus on the bulk of those rights in Amendments 4 through 8, which deal with only those who are in trouble with the law. I mean, if you're not in trouble with the law, your right to a fair trial really doesn't matter that much. You're never on trial, or your right to an attorney, etc. And if you're never suspected of a crime, you're never going to be subjected to a search warrant. They then dress those cases slowly over time. Now that era ends in the early 70s, and we're largely left with just a couple of oddball ones and the Second and Third Amendment. We get to the 21st century, all this issue of gun violence, etc., and the case of, it's 2 cases, Heller, which established owning a gun as an individual right, not as part of a militia, and then most importantly, McDonald versus Chicago, where they ruled that now the Second Amendment applies to state and local governments. So if, in this case, Chicago forbid handguns, you could go directly to federal court and say that's a violation of my personal Second Amendment rights to own a handgun. And that case would be legitimately decided by the courts. You might not win, depending on the particularities of the case, but you would be allowed, it would be a federal question now. Remember, a federal question must involve the Constitution, a federal law, or the Bill of Rights now. So that's the last one. So there's a couple of criminal ones, particularly I think a jury trial in a civil case, and of course the Third Amendment, quartering of troops. So that's all that's left between 1925, the early 70s, and then throw in the Second Amendment in the 21st century. We finally have gotten to a place where John Bingham and the other radical Republicans wanted us to be in 1867. So here we are. The government does not treat you in a certain way as you see expected by the Fifth Amendment, or they violate some aspect of your freedom of expression. You can go to the federal court in Alexandria and they will hear your case in a trial. You might not ultimately win, and we're going to sort out when do you win, when do you lose in the next coming slides. Now, for the rest of this video, I'm going to walk you through the First Amendment and each part of the First Amendment and where roughly today the Supreme Court has worked out a stand on where the line is between what the government can do and what the government can't do. What you can do in each one of these things and what you can't do, or at least if you do, will get punished. First up is the Establishment Clause. Congress shall make no law respecting the establishment of religion. There is obviously a range of interpretations to that. The narrowest of which is it prohibits the United States government from creating the Church of America, or designating the Episcopal Church the official church of the United States, and that's it. And that's as far as it goes. And then you have, perhaps to the other extreme, the people who took Jefferson's phrase from a letter that there should be a wall of separation, as there should be absolutely zero intermingling between the state and religion. So they're the ones that bring the lawsuits about um, "In God We Trust" being on our money, or both the speakers stand in the House of Representatives or protest the expression "a nation under God" in the Pledge of Allegiance. So they are sort of the absolutists, the wall group, if you will. The others are sort of the narrow, as long as there's not some official tie. Now, where is the line? The line is somewhere in between. And you see from this slide that historically, obviously all of you are on your way out, but historically, the place where this gets fought over is in schools. And that makes sense because by the early 20th century, almost every state, if not every state, required parents to send at least some children for some period of time to public schools. So in a nation that was heavily Christian, or at least heavily religious, you now have this daily interaction between what the family expects from freedom, etc., to what the government is providing and the decisions it's making on how to provide it. And for a long period of time, the government was sort of free to do, depending on the community, depending on the state, whatever it wanted in terms of this. And prayers were said, etc. Crosses were placed in schools. It doesn't become an issue until we start getting into that period of recognizing, incorporating the First Amendment, those fundamental freedoms, and having to draw a line. So the notion of an actual prayer in school, the notion of obviously recognizing particular religion, Christianity in particular, the court begins to strike down as inappropriate in a public school setting. Eventually in 1971, because they're getting flooded with these cases, they set a standard called the Lemon Test, which more or less is still what they apply. It's been a little tweaked since then. But they ask when the government attempts to do something that somebody complains about as violating the Establishment Clause in church. They then look at it and subject it to these three standards. Is the purpose of the government action secular, in other words, non-religious? Okay, if the answer is yes, it is non-religious, you proceed to the second question. The second question is, does it hurt or help religion in general, or this particular religion, by having this program in place? The answer is no, it's neutral. It doesn't seem to impact the religion one way or the other. Then you ask the third question. Does it create a circumstance where the government is excessively entangled with religion? A couple of quick examples. I had to spend more time on this in class. Was Louisiana used a windfall from gas and oil leases to purchase, and we're obviously saying this, computers for all students who went to school in Louisiana. You're mandated to go to school. It doesn't matter what school you went to, because you're being mandated to be there, be it a private, religious, or public. They provided you a laptop to use for the course of your school year. Well, one of those absolute wall of separation said, well, tax money providing a computer to somebody attending a religious school was a violation of this. So the court looked at it. So was the purpose secular, to bring modern technology, etc.? Okay, yeah, it wasn't designed to religion. They decided that having these laptops, they were the same laptops. It wasn't they were giving the Catholic students better laptops than the public school students. That it was more or less neutral when it came to impacting religion. And the program was pretty simple. Just send us a roster of your students, and we'll assign that number of computers to your school, period. They decided that was not excessive entanglement. If they had said, we want to see test scores, we want to see pre-testing, post-testing, then the court might have rendered a different decision. But that was one that was constitutional. One that was not constitutional was in Pennsylvania. The state established supplemental salary benefits for teachers of math and science, particularly middle school, because they're having a hard time retaining these people in a good economy. And this also applied to the teaching of math and science in middle school, regardless of public or private. And the court said fine, and it was secular, and it wasn't advantaging religion. But on the last one, when you got into a personnel decision of who qualified to get this salary benefit, who qualified to be hired in a private school, then now this was getting the government too involved in the business of the church, i.e. the church school. So that was ruled unconstitutional. We get these pushes now and then. It's sporadic. One of the things that a Supreme Court test does, it provides all the lower courts, whether they're federal lower courts or they're state courts, with a standard to apply. And if they do it, then the loser will complain. But in all likelihood, the standard will be upheld, and that will be the end of it. It also establishes some consistency across the 50 states. Um, the okay, that's it for that. Now, in a distant second place to the issue of church and state when it comes to public schools is holiday time. Obviously, we're in one right now. I'm recording this a few days before Easter. But the big time is obviously, as you can see, Christmas time. And the court was issuing rulings, very controversial rulings, that Christmas displays could not be, in particular creches, these are nativity scenes, could not be displayed on public grounds or paid for by public monies. And this is a touchy question. And what happened a couple of years later, a community found a way out, a way to use Frosty the Snowman. If you had a display that had recognition of the Christianity aspect of Christmas, nativity scene, then you also had secular holiday, Rudolph the Red-Nosed Reindeer, Frosty the Snowman. In that case, it was just the government recognizing the season, not necessarily Christianity. And now that is to some degree laughable, but it was enough to convince 5 justices to allow it. Now, private, malls, etc., private communities, I mean, they're on their own. They can do whatever they want. I mean, they're private entities. We're talking on public grounds or with public money. Now on to the free exercise clause. In terms of belief, you can believe your left shoe is God. Um, when you act on that, you could be, declared insane or whatever. But beliefs are largely left untouched by the government. It's when action occurs, and when the government chooses or takes an action to interfere with your religious action, the court has set the standard, and you see it right there, that the government must establish a compelling interest for doing that. I think the silliest example would be if you happen to be a practicing Aztec and decide you want to conduct a human sacrifice, that the government would declare protecting the sanctity of life, even voluntarily giving it up, is a compelling government interest, and they would stop you or punish if you did it, and the court would say, yes, the government has a compelling government interest there. You could argue, you could say, yes, oh my God, technically it's violating your right to freely exercise your religion, but in this particular case, the court would say, no, there is a compelling government interest in maintaining life, the police power. There are 2 cases, classic cases from the late 80s, early 90s. The first case, the case of the Lukume Bailu I Church, they had established a church. This is a Caribbean religion combining voodoo and African heritage and even elements of Christianity. They established a church in a retirement community, Hialeah, Florida, and the local community was not crazy about this religion or the kind of people that practiced it. So part of their religion was to, in their ceremony, take a live chicken, behead it, use the blood of the chicken as part of the anointment process. So the town fathers and mothers of Hialeah rewrote their animal cruelty laws to include the beheading of live chickens. It was clearly an attempt to drive this church out of the town of Hialeah, not to protect the lives of chickens. It went to the Supreme Court, and the Supreme Court said very clearly there is no compelling government interest. Chickens are beheaded all the time, all over the country. If they were beheading golden retriever puppies, that might be another matter. So in this case, Hialeah failed to demonstrate a compelling government interest. Then in, I think, 1990, an employment division for Smith, part of the whole anti-drug Nancy Reagan just say no, Oregon established drug testing for eligibility for unemployment benefits. Smith was a Native American who used peyote as part of their religious ceremony. Well, it was a hallucinogen. It was classified as a drug under state and federal law. He failed his test. His unemployment benefits were denied to him. He said, "Wait a minute, you're making me choose between getting money to help me pay my rent and feed my family and my religious belief, and there's no compelling government interest there." The state of Oregon made the case that both to make sure our employment money is being used for proper purposes and to fight this very bad war on drugs, which was reaching its peak, that is our compelling interest. And everyone thought Smith was going to win based on the Hialeah case. He lost. And as a result, we'll talk about on the next slide. In response to the Smith decision, Congress passed the Religious Freedom Restoration Act, known as RIFRA, making it federal law that states and even itself would have a hard time forcing any practicer of religion to make the same decision that Smith had to between some government benefit or maintaining some government requirement in their faith. Now, nobody anticipated it ending up mattering late, well, around the 2010, etc., into the second decade of the 21st century. And we have, I mentioned 3 cases right there. The first 2 arose out of the Obamacare Act. The Affordable Care Act required businesses to provide health insurance and included various contraceptive and even reproductive services benefits had to be part of that. Well, it was challenged by a group of Catholic nuns as saying, hey, we run this hospital, and obviously our nuns don't need this, but people who work for our hospital, if you force us to require this, you're forcing us to act against our religion. And based upon, they challenged that this was actually violating RIFRA, and they won. They won the right not to include this in their package. Then a short time later, the owners of Hobby Lobby, private people, said, we don't think this matches our religious beliefs, and we think RIFRA applies to us too, and they won. Then you had the caterer who did not want to make a wedding cake for a gay couple in Colorado in violation of the current statute. They're saying, wait a minute, this is a RIFRA matter again. You're forcing me. My religion does not recognize this, and if I use my business to provide this, I am being forced to recognize something I don't religiously agree with. He won his case. Now, we take it to the extreme, and you see the final case there. Somebody started a church of cannabis and claimed that smoking marijuana as part of their religious service was protected by RIFRA too. Now, that case has not come anywhere near the Supreme Court yet, but has been shot down repeatedly in the Indiana court system. So I suppose there are limits to how far you can take this RIFRA protections. Next up is freedom of speech, or what is now commonly referred to as freedom of expression, the right to express yourself. So this slide sort of gives away part of what I want to talk about, but what is speech? And I just said it there. It's a manner to express predominantly your political points of view, although it could be non-political too. Although if it's non-political, it has increasingly less and less First Amendment protections. Now, there are 4 common areas of exception. The first one you see there, sedition, advocating against a law and order as provided by a stable government. advocating violence, etc. The original, and we talked about this with in the previous video about the 15 cases. Originally, in the early, first of all, there was no standard until the early 20th century, when finally Schenck established this clear and present danger test, reminding you that it tended to favor the government because they were the ones that were seen as declaring what clear and present danger was. Well, that seems sort of unfair. But then we have that almost 180 by the time we get to Brandenburg in the eminent lawless action standard. It becomes increasingly difficult to punish somebody for speech unless it causes an immediate illegal action. Now, that has all been obviously tested extensively since 9/11 and various provisions of the Patriot Act. Is recruiting people to join ISIS protected? What if they don't have to join? I mean, is that an eminent lawless action? So all of these are, occasionally fuzzy situations. So, but keep in mind, one of the exceptions to free expression is sedition. You cannot, if it is, whether you're using Schenck 100 years ago or Brandenburg now, we're dealing with the Patriot Act and ISIS. If it qualifies as sedition, there is a good chance you can be punished for it, even though technically you're expressing yourself about a political matter. Now, a second objection, or excuse me, a second exception to freedom of expression protection is lying, what is called slander or libel. Libel is written lies, slander is spoken lies. So in the case of freedom of speech, it would be slander. Now, that being said, pursuing people in court for that particular action was made in the 1960s much tougher for people who are public persons, and those are celebrities, politicians, etc. It comes from the case Sullivan versus New York, where if Britney Spears or Donald Trump is trying to pursue somebody in court for slander or libel, they have a tougher standard than you or I. They have to prove that the information was wrong, and that in itself can be difficult and or embarrassing. They have to prove in court with evidence that the speaker, publisher of it knew it was wrong, and that can be problematic. And then they have to prove with evidence that the speaker or publisher did this lying for the express purpose of hurting the other person, and there had to be harm to the other person. Why I don't hear a lot of celebrities winning cases from the National Enquirer, etc., is the old adage, the only bad publicity is no publicity, that a lot of these celebrities, when these stories appear, they become bigger names on the internet in social world, and they actually become richer. So it's a little hard for them to demonstrate harm when their bank accounts have gotten bigger. The third exception is obscenity. Now, the easy thing to talk about there is how do you define it? And that the court struggled with that. In the early 1970s, they established something called the Miller test to use for themselves and also to be applied by lower courts and state courts. The Miller test, something is constitutionally labeled obscene and then can be regulated, if not outright prohibited, if it meets all four of the following standards. It is of clear sexual nature. It portrays the sexual behavior in an offensive, clearly offensive way. Where are my notes? I'm sorry, three steps, not four. And the entire thing being challenged, a magazine, a film, etc., has no artistic or political value or literary value. So a magazine that could be clearly portraying sexual activity in a patently offensive way, as if it's having political commentary, if it's giving you cookie recipes, you have to look at it in its entirety to label it obscene, and particularly for the purposes of banning it. Regulating it in terms of age access is okay because, as I mentioned, people under the age of consent have not no protections under the Bill of Rights, but less protection under the Bill of Rights. So being obscene is another exception, and this applies both to expression and the press. Now, the next issue is, what if it's not spoken? What if it's not necessarily traditional words? Um, we have the case, and we talked about it in the 15 key cases, the Tinker case, where the students were wearing a black armband. Did that merit consideration under expression? Yes, it did. In the Cohen case in California, he didn't utter the word, but he walked in during the Vietnam War to a public courthouse wearing a jacket that on the back was stitched, "Stop the war, F the draft," and the full word. That was protected speech. In fact, I think it's that case, and one of the justices had a famous quote of one man's vulgarity is another man's lyric, something to that effect. And then probably the most controversial of all, again around in 1989, is burning an American flag. There's no spoken word there, there's no written word there. Is the symbolic act of burning an American flag protected? So a lot of people were surprised that the vote was yes, it is protected. That's, by the way, the closest we've come to a constitutional amendment in recent memory. The new Republican Congress in 1995 passed a proposed amendment to allow states to make burning an American flag a crime. The House passed it, the Senate missed it by one vote. So that's as close as we've come to a new proposed constitutional amendment. So symbolic speech has to be treated by the same standards as spoken. Now, the least protected category, although not entirely unprotected, is commercial speech. And the image I put there shows you, this is obviously a long time ago, in the early 1970s, the Federal Communication Commission forbid cigarette advertising from being on television. The actor Tom Selleck, one of his first paying jobs was the Marlboro Man in a television commercial, like in the late 60s or early 70s. For a long time, hard alcohol was prohibited, and that is only something that has changed recently. So commercial speech can receive some First Amendment protection, but it is going to be the easiest one for the government to justify restricting. Now, finally, the final three: press and assembly, and as an extension to assembly association. If you are going to truly limit the press, and we're predominantly talking about the printed word, the only way to effectively do that is to stop the printing from occurring in the first place. That is referred to as prior restraint. There was no constitutional standard until you see the Incorporation case there in 1931, where a local prosecutor wanted to stop the publication of an embarrassing investigation into their prosecution of a criminal enterprise in Minneapolis, Minnesota. The case goes to the Supreme Court, and the court sets a very high standard in terms of granting prior restraint to the government. It's only generally going to be when it comes down to two things. One is national security, or the other is maintaining a fair trial. And I want to talk about that when we talk about shield laws there at the bottom left. The biggest test of that, I think probably even to today, is the New York Times and Washington Post wanting to publish the Pentagon Papers, which were these stolen documents describing the misdeeds of the Johnson-Kennedy administration at the start of the Vietnam War. And the court essentially said, sorry, you should have done a better job of security. The papers have it, they can publish it. If it was something about ongoing operations in Vietnam or somewhere else, perhaps it would have been another matter, but describing the history of what had happened years before, sorry. Now, shield laws for reporters. Do reporters, as part of freedom of the press have a right not to reveal their sources for stories. In this particular case, the one you see there had to do with the trial of the movie theater shooter from the early 2000s. This reporter, and I forgot her name, she had gotten a hold of a fact in the case that there was a journal kept by the guy whose name I forget now. And the judge had put what was called a gag order, that people involved in the case were not supposed to talk about the case, one of those exceptions to protecting free press. And they did, and they wanted to know who told you this, because I'm going to get them. She was an online reporter in New York. This case was in Colorado. The judge was in Colorado. Colorado does not have any law protecting the sources of journalists. New York does. There is no federal law protecting journalists. And it was almost going to become a struggle perhaps between the governor of Colorado demanding the governor of New York arrest her and send her to Colorado. They ended up working out some sort of deal. There was a reporter for, I think, the Washington Post, who now is a commentator on CNN named Judith Miller, who had information about the invasion of Iraq and the stories about that. She actually sat in a federal prison for months, not willing to reveal her sources, and it was only because her source decided to reveal himself that she was allowed out. In another world, we could have a class discussion over whether or not there should be shield laws. There isn't. Now, the last right protected we call assembly, and it is also tied to petitioning and what is now in modern times referred to as the right to associate. Governments do have a right under the police power to regulate access to public places. In regulating that access, in giving access or denying access, they cannot take into account the content of the event or the participants in the event. They can establish reasonable time, place, and manner restrictions. So they can deny a 3 a.m. permit. They can deny a permit demanding access to the middle of the road. They can deny the use of, explosives as part of the demonstration, given the fact it might be, not necessarily a 4th of July type thing. The ability of private enterprises, malls, etc., to regulate access, assembly, etc., is greater. However, they would run in violation of the Civil Rights Act if they were to discriminate in their decisions based on race, gender, ethnic origin. I don't think the law has yet been changed to talk about gender identity, but in that case, they'd be violating federal law. The Civil Rights Act, it would not be a matter of violating the assembly provision of the First Amendment. That applies to governments, predominantly state and local. Although obviously we live near DC, the federal government has a lot of land that it distributes. The court has also become very protective of groupings, we'll call them factions or whatever, and their right to act independently of government interference. We have 2 cases separated by nearly 3 or 4 decades. In one case, the government of Alabama was trying to intimidate the NAACP by getting a list in the early 60s or late 50s of their membership, and the court said, no, you don't have a compelling government interest. It's clearly just you want to intimidate them. You can't have the list. And then the Boy Scouts in the early 2000s, excuse me, this isn't true anymore, did not allow homosexual scoutmasters. And they won their case. They won the right to, in terms of maintaining the kind of association they want, independent of government interference, they established that right. Now they voluntarily dropped that. So that's where we are on the First Amendment, the fundamental freedoms.